This is information in relation to when a matter before the criminal courts can be regarded as an indictable matter, which must proceed to the District Court or the Supreme Court, or a summary matter, and also a brief explanation of when indictable matters may be dealt with summarily, that is, in front of a magistrate. In the state jurisdiction in Queensland, the law is primarily governed by the Criminal Code and also other legislation such as the Drugs Misuse Act, the Police Powers and Responsibilities Act, the Regulatory Offences Act or Summary Offences Act, and the Bail Act, things of that nature. Unless otherwise stated, you can assume that the matter will be a summary matter. So how do you determine what's an indictable matter and what does it mean when we say this is an indictable matter? Well, an indictable matter is a matter that can be dealt with by virtue of an indictment. And an indictment is something which is presented in the district or Supreme Courts. It is, in general terms, a more serious offence. So, as you might expect, for example, matters of murder, arson, things of that nature are what we call indictable matters, and they must be dealt with in the superior courts, either the Supreme Court or the District Court. Other matters are indictable but can be dealt with summarily, or perhaps must be dealt with summarily, and there have been a whole lot of changes in 2010 following the Moynihan reforms, where matters such as going armed so as to cause fear, which previously had to be dealt with on indictment, must now be dealt with summarily, meaning in the magistrate's court, even though technically it's still an indictable offence. Now, having confused you thoroughly, can I explain it this way? In the state jurisdiction, when we consider indictable offences, we're probably looking at two sources of law. The first is the Criminal Code and the second is the Drugs Misuse Act. They're the primary sources of where you'd find the indictable offences. And the technical side relates to sections 552A through to D, which provide the laws, the rules, if you like, about which ones are dealt with, which indictable offences are dealt with summarily and which are dealt with on indictment. But there is an easy way. There are a number of, if I can call them, cheat sheets or summary guides. The one in front of me at the moment is from Peter Shields' lawyers, and Peter has gratefully allowed me to reproduce this and provide it to you. So it's a summary sheet like that. I use it all the time, and in this summary sheet you'll see that there are 4 columns. The first is that in relation to a certain offence, which is over here, described here, there's a maximum penalty and there's a code determining which ones must be dealt with summarily, meaning must be dealt with in the magistrate's court, even though they're indictable, matters which must be dealt with on indictment, and then the final 2 columns are where defence get to choose, and the last one is where prosecution get to choose. So let me give you some examples. Say, for example, going armed so as to cause fear, section 69 of the Criminal Code, maximum penalty 2 years. Following the Moynihan reforms in 2010, that is now a matter which must be dealt with in the magistrate's court. So the law prescribes, through amendments to section 552BA of the Criminal Code, that that matter, albeit indictable, must be dealt with in the magistrate's court. Previously, in 2009, it was complete opposite. It was a matter that must have been dealt with in the district court. And we're seeing this a lot. Many of the charges which were previously dealt with in the district court are now being dealt with in the magistrate's court. Section 72 affray is in the same sort of category. All right, so let's look at some examples of where the matters must be dealt with on indictment. And there are plenty of them, but I'll just take 1 or 2. So, for example, torture. Section 320A of the Criminal Code, maximum penalty 14 years, must be dealt with on indictment. There are some which can be dealt with at the defence election, and we call that a section 552B matter. So, for example, dangerous operation of a vehicle with circumstance of aggravation, the defence have the election to deal with that in the magistrate's court or in the district court. I say with a circumstance of aggravation to include things like drink driving or having a previous conviction for dangerous operation. and we contrast that to dangerous operation of vehicle simpliciter, where there is no aggravating circumstance. In that case, that's a matter which must be dealt with summarily, meaning in the magistrate's court. Another common example where the defence have an election is assault occasioning bodily harm, which is section 339 of the code. So assault occasioning bodily harm, if a client is charged with that offence, then the prosecution have no say in the matter. Defence have all the say and can simply decide to have the matter dealt with in the magistrate's court, that is summarily, or in the district court by way of indictment. It's their choice. Contrast that to serious assault, which is section 340 of the Criminal Code, where prosecution have no say in the election. That's purely defence have no say. That's purely a prosecution election to determine whether the matter should be dealt with in the magistrate's court, that is summarily, or in the district court, that is on indictment. There is also a reckoner in relation to drugs misuse matters. And here, generally speaking, if there's an election, it'll be available to prosecution. In general terms, the more simple of the offences are dealt with in the magistrate's court, for the most part, because they must be dealt with in the magistrate's court. So, for example, possession of a utensil, a bong, for example, must be dealt with in the magistrate's court. If we go to the opposite end of the scale, the most serious of the drug-related matters, that is trafficking, must be dealt with on indictment, either in the district court or the Supreme Court. And then we have a whole range of matters which are indictable offences, which must be dealt with, or may be dealt with in the magistrate's court or the district court at the election of the prosecutor. So, for example, the prosecutor have an election to deal with the question of supplying dangerous drugs if they're a Schedule II drug, that is cannabis, for example, provided it doesn't exceed certain levels and provided it's not aggravated supply including supplying to a minor or person with intellectual impairment in or near educational institution or correctional facility, or to a person who's not aware of what's being supplied. So, generally speaking, in relation to drugs matters, they are dealt with it for minor offences in the magistrate's court, and they can be mostly summary matters, but where they are indictable, for the most part, the prosecution get the election to determine. So, in summary, it works like this. If you have a client who's charged with a matter under the Criminal Code, try to obtain one of these reckoners. It's much easier than working your way through the election legislation. Have a look at the reckoner and determine whether it must be dealt with in the magistrate's court, that is summarily, must be dealt with on indictment, generally the district court, but sometimes the Supreme Court, or it's in that hybrid situation where it may be dealt with at the election of the defence or the prosecution, one way or the other. In relation to drugs misuse, again, if you can, have a look at the reckoner, and that will be an easy way to determine the jurisdictional aspects of it. I hope this has been of some help. Thank you.